So at the end of the time, once you talk to him and once you talk to Mr. Godbee and you've reviewed your other materials, what'd you do next?
Well, I notified the Attorney General that we had waived. We had previously waived on the file.
And did you have a recommendation as to whether you continued that waiver?
Either at that time or subsequent to that, I did. I had looked at the file. My strong belief, and by the way, this is very common, we rarely intervene because oftentimes the factors for intervention
Objection
are
to
not
non-responsive.
Let me ask you, what was your opinion after you talked to Mr. Godbee and looked under the circumstances? By the time you talked to the Attorney General, what was your opinion as to what you should do?
There was no basis for us to intervene in the case.
Did you have that recommendation to the lieutenant? I mean, did you have that?
I would object again.
I'm not suicidal, Your Honor. I'm not, I promise. Did you have that, did you share that opinion with the Attorney General?
My recollection, yes, I did share with him what had happened. The waiver had been filed, and the reason for the waiver was there was no basis for us to intervene.
What was the Attorney General's reaction?
He was not happy with that response.
How did he show he wasn't happy?
He informed me that he was surprised and not happy that we had waived. He wanted me to reconsider the waiver. He informed me that, in his view, it was improper for a charity to be oppressing a business, especially when the charity was effectively a limited investor in the business. He thought that was out of bounds for a charity to do that. And it was his view the litigation was somehow a form of oppression by the charity toward the business.
So if one were to ask, had he taken a clear-cut position on one litigant against the other in the case?
He was determined for us to intervene, and the basis for that was he was concerned that the charity was doing wrong to the world class.